What is adverse action in a job background check? Imagine applying for a job and feeling confident about your chances. Suddenly, you get a notice that your application is on hold. What could have caused that? It might be related to adverse action. Adverse action in employment is when an employer makes a negative decision based on information found during a background check. This can include denying a job offer, rescinding an offer, or passing over a promotion. When an employer considers such actions, they must follow a legal process called adverse action procedures. These rules are part of the Fair Credit Reporting Act, a federal law that protects your rights. The law requires employers to give you a chance to see what information they used against you before making a final decision. This process helps ensure fairness and transparency. For example, if an employer finds a criminal record during a background check and decides not to hire you, they need to follow these steps. They must first send you a pre-adverse action notice. This notice includes a copy of your background report, a summary of your rights under the Fair Credit Reporting Act, and a statement that the information might affect your employment chances. This gives you the chance to review the report and dispute any errors or misunderstandings. After you receive this notice, you have a few days, usually around 5 business days, to respond. During this waiting period, you can contact the background screening company to correct mistakes or explain your situation. Only after this waiting period can the employer make a final decision. Adverse action can be triggered by various types of information: criminal records, employment verification discrepancies, educational issues, credit reports for certain jobs, motor vehicle records, drug test results, or disciplinary records from previous jobs can all be reasons. The key point is that the employer is making an employment decision based on this information. This process is especially important for returning citizens who have criminal histories. It gives you the right to see what the employer is considering and to challenge any incorrect details. You can also provide context or explain your rehabilitation efforts. The waiting period is your opportunity to advocate for yourself and possibly influence the employer's final choice. Remember, adverse action only applies when an employer receives information through a formal background report. If they learn about your history through other means, like personal research or a conversation, the formal process might not apply. But they still cannot discriminate illegally based on that information. Some states have additional laws called "bend the box" or fair chance laws. These laws often delay when employers can ask about criminal history or requiring them to consider how long ago the offense was and if it relates to the job. If you get a pre-adverse action notice, review everything carefully. Check for errors and contact the background screening company if needed. Keep copies of all your communications. Knowing about adverse action helps you protect yourself during the hiring process. It gives you a way to respond and possibly change the outcome. This knowledge is a key part of your journey back into the workforce, especially after incarceration.